Hello all, this is Dr. Aman Mishra. Uh, can somebody please volunteer as to whether my voice is clear or not?
Yes, sir, your voice is clear.
Let us wait for
Good
5 more
evening, sir.
minutes.
Uh,
Good evening to all.
sir, I would request you to
My,
please share the PDF first with us so that we can refer it as well for the first unit.
I'm gonna share the PowerPoint presentation, which I'm just gonna show it to you right here. Okay, and I think that would be sufficient for in the terms of your unit test.
Yes, sir, sir. Means you can share that thing in WhatsApp also for group, official group.
Unfortunately, I don't think so whether I'm there connected in your official group or not.
So you can
But if
just share your
somebody,
number with me. I'll just add you in the group right now.
yes, or just somebody can just share me their uh, any WhatsApp number, there I can forward the PPT. That will be
Uh,
fine,
yes, if
and
you
that will
take
be enough
my
for
number.
the unit test one.
Yes, you can take my number, sir.
Yeah.
940.
Do you have my number? What's your name?
Sir Sahil, I don't have your number right now.
Sir, I have
Okay.
a number.
Also, okay. So those who have my number, or anybody who has my number, they can just WhatsApp me. And please, I'll send it to you. Then you please send it in your respective groups. Okay.
Sir, we have to message you for the PPT.
Yeah. Just message me.
Okay, sir.
Yeah. I think most of you belong to the BA or BBA class.
Sir,
BA as well. Okay.
BBL.
Okay. So I was told that many of the BBA students missed my two classes which I have taken only, and unfortunately this section belongs to unit number one, and unfortunately again that is a part of your unit test. So I've been asked to revise chapter one for you so that you can feel a little confident, and with my PPT you can appear for your unit test. So far as unit one is concerned, I am responsible only for unit number one and one only. Okay, and I hope that your other classes are going on well. And this other teacher, what's her name, Miss Pooja, is interested with teaching you with the international law. However, I'll be teaching you some of the units that are there, which will help you in more practical way, in mostly on the Saturdays. So let us keep this link only as the final link for the public international law classes, supposed to be held every Saturday. Okay. Now I think we have almost 36 people. So should we begin? I am turning off my video deliberately because I want to uh, see. I want to show you a presentation which will help you to read. It is very easy, so that so far as the first unit is concerned, you need not worry about the same. It is uploading. Uh, okay, just give me 2 minutes, guys. Right. Am I? My screen is visible to you? Can you see it all?
Yes,
Can
sir.
somebody please? Okay, great. Now please pay attention to whatever I say very carefully, because I'll treat this lecture not as revision, but you see, I'm gonna cover almost every part of it, and within short span of time as much as possible. Okay. So you see, international law is like ghost. International law is like God. To those who believe it, international law exists, and to those who do not believe it, international law simply does not exist. However, now the trend is changing, and many more people and many more states that they are believing that yes, there is an international law which is there, and there is an international constitution which is there well in place. So far as to guide the behavior of the states in the international community, right? I would love to have questions from you either in the middle of the presentation or at the end of the presentation. So I would love to have that, okay? But my suggestion would be you can reserve your questions, and when at the end of the lecture, I'm gonna ask you the same question. Then maybe you can throw some of the question, and if possible, I'll try to answer them both, right? So international law is a law that deals mainly with the relationship in between the states. Okay, it means otherwise it is the law which governs the behavior of the state. Now, international law has it's very old. It has its history. You can trace the history and background of international law as long as the existence of the state. See, there was a once upon a time there were only few states that were in existence, and mainly it was United Kingdom which has ruled almost all over the world, barring few countries like Afghanistan and in some cases like China and even Vietnam. So once upon a time, this entire international community was in existence just under one umbrella, and that was the British colonial period. However, as soon as the states started getting their own independence, starting from the United States of America, then France, and then so many other nations, you see, came to the international plane arena, and as a result, many of the states started dealing with each other as an independent and individual entity at the international level. So this is how marked the beginning of international law. However, uh, after you see during the World War First and during the World War Two, before the creation of the United Nations, there was very much in place the League of Nations, which is the predecessor of the United Nations itself. Yeah, any questions, Babita Singh?
जीरो प्लस लगा लेना अगर ये मैंने किया है तो ये मैंने नहीं किया इतने दूर से मेरे
Babita
नाखून का
ji,
इतने ज्यादा यहाँ दिख रहा है वहां पे थोड़ी
Babita
मेरे इतने
ji,
बड़े नाखून
Jethalal
है
is requesting
कहीं और
you
से
to
खा के
please
आया
stop.
होगा
Babita ji, can you please unmute? Okay, so we have a disturbance here. If somebody knows Babita ji, please tell that we are having disturbance because of her.
टेस्ट एग्जाम में ठीक है यूपीएससी हेलो क्या बोल रहे हो क्या कर लूंगा
बहुत
All right, you see, this is what I love about the online classes. Babita ji most perhaps watching the Halal series in Sub TV. So once again, just to be clear, my voice, am I audible to you all?
Yes, sir.
yes sir
Okay, so I was saying that during the World War One and before World War Two, there was instead of like UN, there was League of Nations, which was a body responsible for the maintenance of international peace and security. However, its activities were been broken by the outbreak of the World War One and the Second World War, and wherein we have seen mass atrocities, the Nazi atrocities, and in other words, what a human can do to another human being. So after the World War II was over, all the international community members they decided to come together, and they decided that we should have one particular document, we should have one particular organization which will guide our behavior in the future. And enough is enough. We won't be tolerating, or we won't be tolerating any such kind of violence which we have seen, any such kind of suffering to the humanity as we have seen in the World War One and World War Two. So there should not be any third world war, or there should not be any bilateral war at all in between even one or two states. And as a result, international members community, they came together and they decided that we should have one particular organization and one particular document which will guide our behavior in the future. The outcome was, the outcome came in the form of the creation of the United Charter in the first place, and by virtue of United Charter, there came the great establishment of the the United Nations Organization, which is now mainly responsible for the development and progressive development of international law, as well as the maintenance of international peace and security. So we will see the role of the United Nations as well as the dominant powerful states. Maybe you see on this coming next Saturday, wherein I'll be dealing with the dominant role which has been played by the powerful nations who were the victors at the World War, and how they have dominated the international scene, and how even now they are continuing to dominate the international scene, and how they are turning their things in their favor so far as international law and community is concerned. Okay, so before going to that, let's have a quick fleeting look at the nature and the development of international law. Uh, uh, and let's understand what do you mean by international law in the first place, right? Because you see, international law is a law which is mainly, it's a huge ocean, it's a huge subject, it's a huge law in itself, wherein now there are separate streams like international investment law, international environment law, but mainly speaking, broadly speaking, international law can be divided into two. One is public international law, and another one is private international law. What is the difference in between these public international law and private international law? We are going to see it very soon. And before that, let's have a look when you say the term international law. So, the term international law and the law of nations are synonymous and equivalent. They could be used interchangeably. And also, the law of the nation means the law of the states, right? So nations, states, countries, nations, this could be used interchangeably, and one should not be confused about the use of the law of nations and the law of the states or international law itself. However, now we are here. This semester is our concern only with the domain of public international law, because it is the subject that we are gonna study together, and that's why we will focus more on the domain of public international law, and maybe sometime later in future or in the next semester, we will deal with the term of private international law, right? So the term international law was first coined by Jeremy Bentham in his work Principles of Morals and Legislation, which was first published in the year 1789. So to most of the jurists of international law, there was another jurist called Hugo Grotius. They considered him as the father of the modern international law. However, for the very first time, the term international law was coined by the great author, the great jurist Jeremy Bentham, sorry, about whom you must have heard or listened or remembered in your jurisprudence subject. So, generally speaking, international law deals with the relationship between the state and the states primarily. Okay, so let me just go back to the slide 2. Okay, so here are some of the definitions which we must see in order to understand what do you mean by international law in the first place. So Oppenheim is a great jurist of international law, and he defines international law as the law of nations, or international law is the name for the body of customary and treaty rules which are considered binding by the states in their intercourse with each other. So it is mainly the body of customary and treaty rules which are considered binding by the states while they deal with each other. So here are the three ingredients of the above definitions. One, it is the body of rules governing relations between states. Second, states regard these rules as binding on them. Nobody forces the states to follow these international law. However, they themselves considered as binding on something binding on themselves. And that's why they follow such rules of international law. Then such rules derive from customs and treaties. Now, this is the basic and fundamental definition of international law. And if you have a closer look, this is a very narrow definition, and which is only confined to the states and the states only. Now, according to Hall, another international jurist, international law consists of certain rules of conduct which modern civilized states regard as being binding on them in their relationship with another. this is just another definition. Then there is five criticisms over the definition propounded by Oppenheim and even Hall. These are these international organizations and institutions are excluded from the definition. Now, one must understand that at the time Oppenheim had came up with the definition, then that time it was totally different, which means international law was not in its original evolution framework at the time when definition was framed. And as a result, after the Oppenheim has given the definition, there are so many latest trends where even international organizations and institutions like the United Nations, other NGOs like Amnesty International, they are playing even vital role. So criticism says that this definition originally does not include this international organization and institutions. And also, individuals are excluded from the purview of definition. This definition does not talk about individuals. Similarly, multinational corporations are also excluded. And lastly, and fourthly, international law, they say, not only derives from custom and treaty, but there are other several sources from which international law can also be derived, right? If you give a closer look at the Oppenheim definition, it says that it is the body of customary rules and treaties. But there are certain other sources of law wherein international law is applicable to as well. Then the term body of rule denotes that international law is static. However, this is not the fact. International law is completely dynamic and keeps on changing depending on the nature of you see international community. Now here comes the most interesting part. Once the definition has been given by Oppenheim, there have been so many changes in the framework of the international community. And you see, the comprehensive work of Oppenheim was first published in the year 1955. Since then, there were so many changes in the international relations, and thus Sir Robert Jennings and Arthur Rafzold, another these two jurists of international law, edited the work of Oppenheim and published another version in the year 1992. Because you see, from the year 1955 to the year 1992, the international law has evolved like anything on the planet Earth. So as a result, a new revised definition has been provided by these two authors, Sir Robert Jennings and Arthur Watts, which we'll see now. Well, this is the revised definition of Oppenheim provided by Sir Jennings and Watts. They say international law is the body of rules which are legally binding on the states on account of their intercourse. Intercourse means their relationship with each other, and these rules are primarily those which governs relations of states, but states are not the only subject of international law. Remember, states now are not the only subject of international law. To many extent, international organizations and individuals may also be subject of rights conferred and duty imposed by the international law. So this is now in this definition, even international organizations, MNCs, and individuals, they have an active role to play. Stark again come up with the definition in the line of Sir Jennings and Dr. Watts. He says international law is that body of law which is composed of great part of principles and the rules of conduct which states feel themselves bound to observe and therefore do commonly observe in their relations with each other, and which also includes the rules relating to international institutions and organizations, to individuals and non-state entities. So everybody, in fact, in international organizations and even to some extent individuals, they are to them also international law, public international law usually applies. I think we'll this another definition being provided by Weisenberger. He says international law is the body of legal rules which apply between sovereign states and such other entities as has been granted international personality. Okay, so okay, skip slide. Yeah, so as I told you before, that there are two branches of international law, broadly speaking. One is public international law, and another one is private international law. Public international law primarily applies to the states. Majoritarily, public international law deals only with the states and the states. However, private international law is directly applicable to the individuals. Private international law are part of the laws of the land, domestic laws of the two countries usually. So, in the law of nations or in public international law, general public international law, general international law is applicable to the state. Private international law applies particular to number of countries. However, public international law applies almost to all the states uniformly. So this is the basic difference between public international law and private international law in a nutshell. Now, this is very much important from your final written examination point of view because I can see the examination paper of you right from here. I can imagine that this question is 100% there when you will write your final exam. So far as public international law is concerned. So you have to listen and you have to understand this concept very carefully. It says the nature of international law. They will ask you as to what is the nature of international law. So to ascertain the true nature of international law, the following questions must be explored. Namely, whether international law is really a law in the first place. And second, is international law a true law in itself? To answer these two questions, we must first understand or we must first ask ourselves as to what do you mean by law? Because if international law cracks or fits into the definitions, into the jacket, state jacket of the definition of law, then only we can call some rules as law, right? Otherwise, these rules are only mandatory rules. They won't become something very much important. So it is important for us to understand what do you mean by law. So when this question comes as to what do you mean by law, there are two views which are needed to be examined. First is very dynamic prominent view which is being provided by John Austin. You must have studied this in the subject of your jurisprudence when you have studied the schools of law and schools of jurisprudence. And second view, which is more positive view, so far as international community members are concerned and international community itself is concerned, is known as the Oppenheim's views on what do you mean by law itself. So we will see one by one both these views, and then later based on the basis of our analogy, our own analysis, we will decide and you will decide as to whether there exists any kind of international law in the first place or whether international law is a true law in the first place. So let us have a look at what John Austin says. This is the image brought before you. He's a very famous you see jurist and you have already studied. So John Austin, he says law is the command of sovereign followed by sanction. Okay, simple. It's very simple. It's very simple to remember. You see, what is law? Law is the command of sovereign and followed by sanction. And there here are the three ingredients. First, he says law is the command. There must be command in order to make or call certain rules a law. There must be command, and that command must come from sovereign. There must be some of sovereign authorities. There must be somebody whom all the people should listen to. And in case of failure to obey, punishment must be followed. Which means law is the command of sovereign followed by sanction. You see, I'll repeat again. Law is the command of sovereign followed by sanction. Now you see the problem with this is when it comes to the domestic setups, when it comes to the national laws, when it comes to the our domestic laws, this definition serves just perfectly. Why? Because you see, Constitution gives authority to the Parliament to make laws, right? And it is the duty of the executive to enforce that particular law. And suppose somebody is not following that particular law, then it becomes the duty of the judiciary to punish such people or such group which will violate the law which will be propounded by the parliament. Unfortunately, so this is the case of domestic law setup like India. Now, when it comes to international law, unfortunately, we do not have any such free organs as we have in our domestic setup. For example, we do not have an international parliament which will dictate the law to all the states. We do not have a particular executive or efficient executive, I would say, at the international law community because we have nobody to enforce the international law in itself. And third, we do not have any kind of international judiciary. Though we have the World Court, which is known as the International Court of Justice at the international level, but only few cases goes up there because of the doctrine of consent in international law. Because you see, again, the problem with international law is you cannot drag a particular state to a dispute before ICJ, because consent of that other state is also very much important, right? So we all these three organs which we have in our domestic setup, parliament, executive, and the judiciary, are missing in the international law. And as a result, if you measure the definition or the international law itself, it fails to, you see, come into the definition provided by John Austin. And John Austin further says that whatever law it may be, if it does not fit or if it does not suit my definition, then that is not a law at all. Okay, so this is what the preliminary objection he has made. And he further said that there are only two categories of laws. One, proper law, and that is and second one is improper law. So whatever my definition is, that is only the proper law, and whatever does not suit my definition, all are improper laws. So he, in this context, gives these further examples. He says that proper laws are those which are laid down by sovereign and followed by punishment. Again, the same which has been reiterated again and again in his definition. Okay, so and he further says that these laws are binding in nature. For instance, laws made by Parliament in accordance with the Constitution of India. So whenever, as and when Parliament will make the law, it will be the duty of, it will be the onus of the normal citizens to follow that particular law. And if somebody does not follow general criminal law violations, which will lead to punishment or sanction, in the words of the great John Austin. And he has also said that there also exists another category of law which I would call improper law. And these improper laws are those laws which are followed by analogy or metaphor. These laws, however, are not binding at all. So it is more like fundamental rights and fundamental duty, it is more like fundamental rights and the other part of the Constitution, which is known as the directive principle of state policy. You see, fundamental rights are enforceable very much in the code of law, but by virtue of Article 38, whatever has been mentioned in the directive principle of state policies, it has not yet been, it cannot be enforced in the court of law, right? So for this improper law, John Austin gives perfect example. He says that laws by analogy, for example, laws of fashion or laws of food, etc. Suppose in the market there comes a very particular, you see, designer coat of Zara, because I am sure that most of the ladies are prone to the product called Zara, and suppose everybody buys it in the class, some of few people don't buy. Do they commit crime? No, because he says these are the laws by analogy. These are the laws decided by the people's analogy, and even if somebody violates these laws, then he or she will not commit a crime at all. Second, improper law, he said that the laws which are there by metaphor. He another example of the law of sport. Now, in the law of sport, suppose the World Cup final match is going on, and suppose Virat Kohli gets out on zero, then does it mean that ICC or the people of India has power to punish him? The simple and plain answer is no, because these are the lightly taken laws, rules, and regulations. It is supposed already, or it is presumed already, that Mr. Kohli will make good run. However, if he fails to do so, he does not deviate himself from the course of the law. So these, as per Austin, these are the improperly so-called laws, which are mainly directed by analogy and the metaphor. And thus, now if you can see, as per Austin, international law is the law improperly so called, and thus it is not the true branch of law. Because again, in international law, as I said, and as I reiterate again, there we do not have any parliament, we do not have any executive and judiciary, and as a result, the definition which is being provided by John Austin will not fit, or the international law will not qualify for the same. And thus, he further states that there seems to be lack of command, sovereign, and punishment in international law, and thus international law is no law at all. Rather, he argues that states follow the rules in international law because they are morally bound to do so and not legally. So he once again categorized this category of international law as improper law, and he said that states do follow these laws because they feel that they are morally bound to follow these law as per the rules, as per the morality, and that's why he stressed that international law is nothing but it is the a positive international morality and no law at all. Any questions so far? Because this is very much important. If you don't understand this, then you won't understand the entire nature of international law, which I don't want you to miss at all. Okay. Any questions so far? You can just raise your hand or unmute yourself and go ahead.
No, sir, it's clear.
Okay. I hope that goes with all the students. We have very few slides remaining, so please bear with me. Now, this is one view which has been provided by John Austin, where he says that international law is no law at all. Then we will see another great jurist of international law, Oppenheim, and what Oppenheim sees. Now, what is law according to Oppenheim? Again, you see, in order to determine the nature of international law, we'll have to determine the nature of law in the first place. And in other words, we have to understand what the law is first. So Oppenheim says that law is the body of rules for human conduct within a community, which by common consent of this community shall be enforced by external power. Then there are these five ingredients again, that international law is the body of rules governing human conduct. There must be a community, consent of the community important, and enforcement by external power. The major thing or major aspect one should look at this particular definition is the word called community. So Oppenheim says that if you can prove that there exists community at international law, then well, there are already existing rules that governs the behavior of this international community. And these states follow these rules by virtue of by virtue of their nature. They consider these rules to be binding on themselves. So, as per the view propounded by Oppenheim, it is very much important that there exists an international community. We will come back to this very particular rule very soon when we'll discuss why international law is a weak law or why international law is a good law. Okay, so uh, thus, it is clear from the discussion that the nature of international law depends on our preference as to what weightage we do give to all Austin's or Oppenheim's definitions or their views respectively. However, definition given by Oppenheim seems to be accepted in as much as exists international community, and also sometimes sanctions follow in case some states violate the international law. Okay. Now, as I said, these are the reasons to believe that international law is a true law at all. Now, there exists an international community, as propounded by Oppenheim already. International law is being practiced since time immemorial through the official relationship by sending diplomats and messengers. If you remember Ramayan, which has been again been showing in the televisions, our Hanumanji was nobody was but a messenger, and international organization contribution. Then we have increased participations so far as international organization is concerned. Now bodies like WHO, UN, ECOSOC, they are playing active role, and we have international conventions and customs in abundance. Then we do have the provisions for the sanctions in international law. Sanctions mean punishment in international law. Punishment again means punishment not to individuals but to states. So there are economic, political, and other kind of sanctions. We'll deal with this part when we'll discuss the means to settle the dispute amicably. Okay. Then yes, we do have UN Charter, which is regarded as the international constitution. We do have existence of the World Court in the form of ICJ and other ICC. Also, we have other tribunals. Also, we have then customary rules. Also, we have. So these are the reasons which will make the audience believe that international law is very much in place. Now, these are the reasons to believe that international law is a weak law, which I have already, referred to briefly in my previous lectures. So, international law is a weak law. Why? Because international conventions and customs are not comparable to the laws of the made by the parliament. Like I said, domestic setup and international setup and their legal settings are totally different. So these are not comparable. Enforceability of international law is not, you cannot compare it with the laws normally made by the parliament. So this is the major issue. Then no court to decide the issue in international law. Though there exists ICJ, but its decision only binding on parties which have volunteered themselves to the jurisdiction. Now, here again, the role of consent by the state plays very much important role because without consent of the state, you cannot drag any country to the ICJ and say that no, 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 you have committed a mistake. Now let's settle our dispute before the ICJ. Consent of that particular country is very much important. This consent part we will see when we discuss the ICJ part. Then enforcement measures are under international law not that effective. Now, Article 24 of the UN Charter, it specifically talked about the enforcement part by the Security Council, but hardly there are times wherein enforcement measures have been taken collectively by the Security Council because there are certain problems which we will discuss later when we discuss the UN part and the UN Charter. Okay, then sometimes rules of international law are violated by the states, specifically during the times of war. So you see, we have so many at the time of war. Uh, Nations and the states break so many. You see, they commit literally war crimes, like as it happened in the year 1994 in Rwanda. It happened in so many countries like Rwanda, right? So the crimes like genocide, crimes against humanity. So when these states violate the law, we don't have much effective remedies so far as international law is concerned. Then there are also principles of non-interference, sovereignty, supremacy, etc., which have created another problems in the progressive development of international law. Okay, now this is the last part of your first unit, if I'm not wrong. It's called the basis of international law. It is again very simple. You will have to go through the jurisprudence knowledge of yours. You have to revive back a little knowledge. And you see, jurists differ on the question as to what is the basis of international law. Thus, again, the following theories have emerged. One is the naturalist theory, and second is the positivist theory, and third one is the eclectic theory, which is a mixture of naturalist and the positivist theory mainly. So one by one, we'll see the basis of international law. First, it is again nothing based on the basis of the natural law theory, which says that it is based on the law of nature. It is something written by the fingers of the god, and international law is eternal and the product of nature. So, like I told in the beginning, international law comes with the secession of states, and as many states started getting their independence, international law evolved by the practice of the states and by the convention and the practices of the states by that time, right? So this is the first. Now this is the basis of international law. Positivist theory again. Here, the consent of the state plays very important role, like I mentioned just now, because without of the consent of the state, you cannot do much in international law. Please understand. Okay. So whenever you frame a particular international convention, the consents of the state must be very much important. You cannot compel any state to come and be a party of your international convention. You cannot compel any smaller state even to come and sign something which they don't want. So consent, this is because the customary rule of international law, right? So free will of the states to follow international convention, sorry, and treaty rules or customs, etc. Okay, so this is the major problem that we have in international law. As to consent of the state, it's very much important, and other states are not required to see interfere into the affairs of the other states. Now we have the last theory, the last slide most probably, that is the eclectic theory. These jurists here in eclectic theory, they have adopted a middle course and prefers to both the theories, which means they say that yes, we do agree that international law is the product of natural law as well as it is something which the state follow by consent, right? And they believe that international law is a law in question, is a law which is being followed by consent as well as law by nature. Now, this marks the end of Unit 1 in your syllabus of Public International Law. If somebody has question, and unfortunately, I'm very much sorry that you were not party to my previous lecture, wherein I have dealt with the provisions of the United Nations Charter, and wherein we have discussed the main practical aspects of international law and when the states can use force under international law. Okay, any questions so far? If there are any questions,
What type of
please
questions we
feel
can
free to ask.
so what type of questions we can expect for objective point of view? Because this is more of
I
means definitions are more of theory nature. So
I cannot help you at this moment because I'm not the one who's gonna you see set this paper. But to the people those who are I think will set the paper. My presentation is already with them. So far as chapter one is concerned, they please focus on my presentation part. And
okay.
I'm sure that you all must have heard this. And if you have any questions, please feel to ask. I'm always there. My number is always there, almost with I think with everybody. And if it's not there, I'm quite unpopular man. You can just Google me and find my number. By the time, if you have any questions, and please make it a point that on Saturday, I know that Saturday is a party day for most of you, but nowadays we are all at home, so we can be there on Saturday, wherein I would like to take in a week a lecture so far as public international law is concerned. And there are so many interesting units, you see, law of treaties. I'm going to tell you the real practices they do at the ICJ and the cases ICJ has decided from you see, and how international law has been developed so far. So it is going to be very much interesting session. But I would like if you can contribute a little, if you can, you see, interact with me a little, and maybe we can have a internal competition on the international law, right? This is just a suggestion in the future times to come. If you guys are on for this, then I may work for this a little, and we can have we can divide you into a group of two or three people, and you can act as nation itself, representatives of the nation. Somebody could be the prime minister, somebody could be the president, somebody could be the ambassador to a particular country or the United Nations itself. So you can make a team, and we can have you see a model form of General Assembly or the Security Council. That I'll think of something, but provided you should be interested in the first place. Okay. If anybody has a question, please raise your hands. I think I have got the message from whom? Garima, I guess. Right? Garima, can you send me your email ID, please? Am I audible? Friends, am I audible?
Yes,
Yes,
yes.
sir.
Okay. Somebody asked Garima to please send her email ID. I'll send the open presentation right away, which will help you. Or do I have option to share here itself? Somebody any idea?
Oh, sir, here you have option, but we can't save it in files.
You cannot save it.
Yeah, it's saved in the software itself, but not in the laptop.
Mm-hmm. Hey. Okay, then maybe if Garima is not here, somebody else can message me and forward it to you. Please message me with your email ID. Okay. And somebody who is messaging me, please make sure that this PPT reaches in the group. Okay. And if you guys do not have any questions, then I'll just stop presenting and show myself up if my video works at all. Am I visible? Is my video working? This test?
Yes,
Yes,
sir.
sir.
Great. I'm sorry that I could not see you all. Had you been in our class, the situation would have been different, I'm sure, because it's always interesting to learn with you guys in the real classroom. I'm not sure that whether you have listened to my classes before, because but anyway, the situation is a little difficult here in Pune. Things are worst, and I hope everything is good at your end. Please take care of your family members. Please take care of yourself. And please, for God's sake, don't go out. And we will meet soon on next Saturday. Okay? All the best for your unit test and all the best. And please come on Saturday, yes, if possible. And Saturday we are gonna start the new unit called um, it is called uh, Law of Treaties, which is very much interesting. Okay, so see you guys. Bye bye. Have a great time.
Thank
Have
you,
a great
sir.
Saturday now, and study well for the unit test. Right? Don't party around just because it is Saturday. See you soon. Bye bye.
Thank you,
Thank you,
sir.
sir.
Thank you, sir.